A very warm welcome to my YouTube channel. Let's know law. Myself, Maninderjeet Kaur Poparai. Today I'm here with a new judgment, and its name is Vijayee Singh and other versus State of UP. And it is a very important judgment of the evidence law. It was delivered in the year of 1990 and its AIR number is 1459. So, in the petitioner side, there was Vijay Singh and other, and in the respondent side, there was State of UP. This judgment was delivered on 20th of April 1990, and the bench comprises of Justice Reddy, Justice Pandey, and Justice Fatima PV. So, a very important section of the Indian Evidence Act was discussed in this judgment, and this section was Section 105 of Evidence Act. So, the section 105, when the law said that when a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exceptions in the Indian Penal Code or within any special exception or proviso contained in any other part of the same code, that is IPC, or in any law defining the offense is upon him, and the court shall presume the absence of such circumstances. So this was the section 105 of the Evidence Act, and there was two illustrations which are enough to describe this section. So first one is, a accused of murder alleges that by reason of unsoundness of mind he didn't know the nature of the act. The burden of proof now is on the A. Secondly, in a case where A accused of murder alleges that by grave and sudden provocation he was deprived of the power of self-control, now its burden is again on the person who alleges that, that is A. So this was the section 105 of the Indian Evidence Act, and mainly this was discussed in this judgment. So the facts of the case are as: on 29th May 1981 at about 8 a.m. a grey rioting took place in the village of Tiro in Varanasi district. In the course of the said rioting, two persons, Mahendra Singh and Virender Singh, deceased number 1 and 2, were killed, and Vijay Narayan Singh, prosecution witness 1, Uma Shankar, prosecution witness 2, and 1 Kailash Singh received injuries. In respect of these offences, 14 accused were tried under Section 148 and 302 read with Section 149 of the IPC. There, a person named Chirkut Singh, which was accused number 6, was tried for offence punishable under Section 307 IPC for attempting to commit the murder of prosecution witness 1 and remaining accused under 307 read with Section 149 of IPC for causing injuries to Uma Shankar and prosecution witness 2 and Kailash Singh. It is alleged that the material prosecution witnesses, deceased persons, and the accused belong to the same village. Since 1972, there have been disputes between these two rival groups. A number of cases were also pending in the courts. The convicted accused preferred appeals. The state also filed appeals for enhancement of the sentence. A division bench of the Allahabad High Court consisting of Justice Karchu and Justice Agarwal heard the appeals. Justice Karchu allowed the appeals filed by the accused and dismissed the appeals filed by the state. But the other learned judge disagreed, that is Justice Agarwal, and dismissed all the appeals concurring with the trial court. Now the matter came up before a third judge, that is Justice State. He took the view that only such of those accused to whom specific overt acts were attributed could be convicted, and the others should be given benefit of doubt. In the view of the matter, he confirmed the conviction of accused number 1, 3, 4, and 6 and acquitted the rest of the accused. Now, accused number 1, 3, 4, and 6 applied for special leave in the Supreme Court, which was granted by the Supreme Court, and the state has preferred appeals against the acquittal of other remaining 10 accused persons. So, in this judgment, on the day of occurrence at 8 a.m., prosecution witness Vijayee Singh went to his pumping set. Prosecution witness 2, Uma Shankar, and his relation Kailash Singh were also at the pumping set. Deceased number 1 and 2, that is Mahendra Singh and Virendra Singh, were proceeding along with the Rasta toward the pumping set for taking bath. When they reached near the Kandhar, that is the old building of Vijay Pratap Singh, accused number 5, Lalan Singh, exhorted the other accused who were all lying in wait to kill them. All the 14 accused emerged out of the Kandhar, that is the old building. Out of them, accused number 1, 3, 4, and 6 were armed with guns and the rest were armed with lathis. They advances toward deceased number 1 and 2. Accused number 1 fired a shot which hit deceased number 1 and he was immediately also shot at by accused number 3, that is Ranjit Singh, and he fell down. In the meantime, accused number 4, Ram Brak Singh, fired at deceased number 2, Virendra Singh, who fell down, and both deceased died on the spot. The other accused carrying lathis advances toward prosecution witness 1, who ducked and escaped unhurt. Then the lathis wielding accused assaulted prosecution witness 1, Vijay Narayan Singh, prosecution witness 2, Uma Shankar Singh, and Kailash Singh. Prosecution witness 1 managed to escape and ran away. The trial court, relying on the evidences of prosecution 1 and 2, prosecution witness 1 and 2, and who are the main eyewitnesses, convicted all the 14 accused of the offences for which they are charged, and the substantial sentences awarded is imprisonment for life under section 302 IPC, read with section 149 of the IPC. So, it is contended on behalf of the state that the occurrence has taken place in broad daylight, and merely because the witnesses are interested, their evidence cannot be rejected, and that the view taken by Justice State is incorrect. On the other hand, the counsel appearing for the accused submitted that the witnesses who were partisans and were highly interested have made omnibus allegations, and it is highly dangerous to accept their evidence because there is every likelihood of innocent persons having been falsely implicated. It is also their further submission that the prosecution has not came forward with the whole truth, and that the origin of the occurrence has been suppressed in as much as injuries to some of the accused persons have not been explained, and consequently it must be held that occurrence did not take place in the manner alleged by the prosecution, and that under these circumstances the truth from falsehood cannot be separated, and therefore none of the accused could be convicted. Now, according to Supreme Court, before it considered these tribal contentions, some of the facts which are not in dispute may be noted. That is, there was a long-standing rivalry between the two groups. The time and place of occurrence are not in controversy. Thirdly, that the two deceased persons died of gunshots injuries also is not in dispute. And lastly, prosecution witness 1 and 2 also received injuries during the course of this occurrence. So, in the case before Supreme Court, as per the evidence of the material witnesses, the two deceased were only proceeding along with the Rasta toward the pump set for taking bath. Even on the plea set up by the Chirkut Singh, that is accused number 6, it is not stated specifically that deceased number 1 and 2 were armed with any deadly weapons. Therefore, the assailants had definitely exceeds the right of private defense when they went to the extent of intentionally shooting them to death by inflicting bullet injuries. Therefore, the offence committed by them would be one punishable under section 304 part 1 IPC. Supreme Court accordingly set aside the conviction of the appellants. Accused number 1, 3, 4, and 6, Vijay Singh, Ranjit Singh, Rambrik Singh, and Chirkur Singh, respectively, for an offence punishable under Section 302 and read with Section 149 of the IPC, and the sentence of imprisonment for life awarded thereunder. Instead, they were convicted under Section 304, Part 1, read with Section 34 IPC, and sentenced each of them to undergo 10 years of imprisonment. The other sentences or convictions awarded to them are confirmed. The sentence falls shall run concurrently. In this court, the Supreme Court held a fact is said to be proved when, after considering the matters before the court, either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it exists. A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. A fact is said to be not proved when it is neither proved nor disproved. The maxim that the prosecution must prove its case beyond reasonable doubt is a rule of caution laid down by the courts of law in respect of assessing the evidence of criminal cases. So, Supreme Court held that Section 105 places burden of proof on the accused in the first part, and in the second part there is a presumption which the court can draw regarding the absence of the circumstances, which presumption is always rebuttable. Taking the section as a whole, the burden of proof and the presumption had to be considered together. It is axiomatic when the evidence is sufficient as to prove the existence of a fact conclusively, then no difficulty arises. But where the accused introduces material to displace the presumption which may affect the prosecution case or create a reasonable doubt about the existence of one or other ingredient of the offence, and then it would amount to a case where prosecution failed to prove its own case beyond reasonable doubt. The Supreme Court held the initial obligatory presumption regarding circumstances gets lifted when a plea of exception is raised. More so when there are circumstances on the record gathered from the prosecution evidence, chief and cross-examinations, probabilities, and circumstances, if any, introduced by the accused either by adducing evidence or otherwise creating a reasonable doubt about the existence of the ingredients of the offence. In case of such a reasonable doubt, the court has to give the benefit of the same to the accused person. So, according to Supreme Court, the presumption regarding the absence of existence of circumstances regarding the exceptions can be rebutted by the accused by introducing evidence. If from such a rebuttal a reasonable doubt arises regarding his guilt, the accused should get the benefit of the same. Such a reasonable doubt consequently negatives one or more of the ingredient of the offence charged. For instance, from such a rebuttal evidence, a reasonable doubt arises about the right of private defense, then it follows from the prosecution has not established the necessary ingredients of intention to commit the offence. In that way, the benefit of reasonable doubt, which arises from the legal and factual consideration even under Section 105 of the Evidence Act, should necessarily go to the accused. It further said that Section 3 is so worded as to provide for two conditions of mind. First, that in which a man feels absolutely certain of facts, in other words, believes it to exist. And secondly, in which, though he may not feel absolutely certain of a fact, he thinks it is so extremely probable that a prudent man would, under the circumstances, act on the presumption of its existence. The Evidence Act, while adopting the requirement of the prudent man as an appropriate concrete standard by which to measure proof at the same time, contemplates of giving full effect to be given to circumstances or conditions of probability or improbability. It is this degree of certainty to be right where the circumstances before a fact can be said to be proved. the general burden of establishing the guilt of accused is always on the prosecution and it never shifts. Even in respect of the cases covered by Section 105 of the Evidence Act, the prosecution is not absolved of its duty of discharging the burden. The accused may raise a plea of exception either by pleading the same specifically or by relying on the probabilities and circumstances obtaining in the case. So, in the instant case, as per the evidence of material witnesses, the two deceased were only proceeding along with the Rasta toward the pump set for taking bath. Even in the plea set by the accused number 6, it is not stated specifically that the deceased number 1 and 2 were armed with any deadly weapons. Therefore, the assailants had definitely exceeded the right of private defense when they went to the extent of intentionally shooting them to death by inflicting bullet injuries. Therefore, the Supreme Court held that the offence committed by them would be one punishable under Section 304, Part 1 of IPC. The conviction of accused number 1, 3, 4, and 6 under Section 302, Red V Section 149 of IPC, and the sentence of rigorous imprisonment for life awarded thereunder is set aside, and instead they are convicted under Section 304 Part 1 Red V Section 34 IPC, and each of them sentenced to undergo rigorous imprisonment for 10 years. So their other convictions or sentences are confirmed the sentence to run concurrently, and in this case the Supreme Court refers so many cases, and there is a list of cases. If you are interested, you may note these references from this slide. So in the end, I just want to say thank you so much for all, and if you like my channel and if you like the way of sharing knowledge, please like and subscribe my channel, and thank you very much.